I've titled this next set of slides, Interpretation of Statutes and the Will of the People. Because in interpretation of statutes, a major theme is that what we're trying to get at is what the people's will is in their democratic legislation. So they elect legislators and they expect them to be working for them and doing their will, right? So I think that's an appropriate title. So let's get into it. There are three very different rules for interpretation. One is the textual rule, made famous, of course, by Justice Scalia. And the recent nominee to the Supreme Court says she's going to be a Justice Scalia judge. She worked for Scalia, and she's going to follow his textual rule. Now, another rule, which is actually the oldest of the three rules, is called the mischief rule, and we'll take a look at this because it's very historically important in terms of showing us that intent was deemed important in old times states, perhaps more so than what the actual text was said. And then the other one the third one is called the purposive rule, which is more of a modern version of the mischief rule in some ways. So let's proceed. The textual rule. This is a very formalist doctrine, very formalist theory. So that runs contrary to really the directions that the court had taken starting in the early 20th century under Holmes and Brandeis and Cardozo, where they were opposed to formalism in the law. And so, textual rule isn't really going back to the previous rule because that's the mischief rule. But it's, so when we talk about textual rule, it is a formalist rule. Okay, formalist rule in which the interpretation of the law is primarily based upon the ordinary meaning of the legal text. Which ordinary meaning? Is it the ordinary meaning of the drafters who wrote it? Or is it an ordinary meaning as people understand it today? As the judge sitting today hearing the case, he would be saying it. I think Scalia would say, well, what was the original intent? So that implies to me that he wants us to be governed by what people thought many, many years ago when they made this rule. When they maybe made this particular interpretation of the statute, what did they understand it to mean? We're not going to be messing with trying to figure out what it should mean today and come up with a better rule for today. We're going to stick with what we had. It's like buying a nice suit back in the 1920s, pulling it out of the closet in 1980 and putting it on and saying, isn't this a wonderful suit? It's a zoot suit. You're going to look very odd. So, upon the ordinary meaning of the legal text, where no consideration is given to non-textual sources, such as the intention of the law when passed, such as the problem it was intended to remedy, which is very much what the mischief rule talks about. That's the mischief. What problem was going on that was intended to be remedied by the rule. Or significant questions regarding justice. You're not going to consider those things. You're not going to consider whether or not this law is the more just rule. So forget about the California rule on comparative negligence. The California court did that as a common law court would do that, trying to do what is more just in people's eyes, in a modern person's eyes, rather than maybe what might have been thought of just 100 years ago. And so that's why they adopted, not the legislature, and many states adopted the comparative negligence rule because judges thought it was a better rule, and I agree. The textual rule. In most cases, statute can be taken literally to effectuate that will. I think in many cases, a statute will be, and you see it in the Supreme Court that in many cases, textualists and others who are following maybe a different rule, whether they're following the purposes rule or the mischief rule or a textual rule, oftentimes judges will come up with the same kind of interpretation of the statute. So you might say, well, what's the big deal? Well, it makes a difference in a few cases, doesn't it? And that's where it comes into play. And I think it also makes a difference in how people view the rules. If you're following a textual, literal rule, people are going to look at the judges as if they're, what, very book-knowledged, that they're very much robots, that they're doing things and oh, this is what the legislator said, so that's what we're going to do. We're not going to think about what they intended to do. We're going to just simply do what we understand the text in its ordinary meaning to do. And if they were lousy draftsmen, that's not our fault. And so applying a statute to interpret it in the word's ordinary meaning more often than not will effectuate that will. So it's not maybe the worst thing in the world. Okay, TVA versus Hill. Plaintiffs argued that a dam construction would destroy the critical habitat and endanger the population of snail darters. Snail darters were very small little fish that existed in those Tennessee valleys and hills in a very limited extent. So it had to have a certain kind of stream, shallow water. It couldn't exist in deep water. It was adapted to living in those shallow streams up there in Tennessee that were going to be flooded by the TVA dam. Anyway, based on the wording of the act, Congress viewed the value of the endangered species as incalculable, because Congress has said that. Just looking at the wording of the statute, you cannot continue with a project if it's going to result in the termination of an endangered species. And so until Congress decided otherwise, the courts would enforce the law, not allowing violations to continue. So this was an actual case that was heard when I was in law school, and I remember it very well. I remember thinking at the time it was an odd case because I wound up agreeing with Justice Rehnquist, who was actually an original intent person, but wasn't applying textualism, I think, in this case. He was being more, I would say, pragmatic and not maybe very, very principled. So, anyway, dissenting Justice Rehnquist agreed with the district court in their refusal to issue an injunction. He agreed that the TVA was in violation of the Endangered Act, but thought there should be a balancing of equities. So they were going to hold up the building of this dam, which would provide more electric power to people in the area, that would help industry and help homeowners cut down on the cost of that. And also, if you think about it, a dam is one of those kinds of energy sources that is not damaging the planet. So this is clean, the kind of energy we really want to have, right? And they're holding up this dam because of a little fish that had no commercial value, had absolutely no commercial value, and wasn't being fished for food. It was just a fish that existed in these streams, just like maybe there are shrews out in the grass. Do people eat shrews? No. They're very small little animals that are running around. Same way with these snail darters. And I guess they ate snails, which, fine, you know, but I'm sure there are other ways of getting rid of snails if that's the problem. Anyway, Rehnquist agreed with the district court in their refusal to issue the injunction. He agreed to TVA's was in violation of the Endangered Species Act. So he said, yes, this violates the words of the act, but thought there should be a balancing of the equities shortly afterwards. The Congress amended the act to allow exemptions. Okay, so they did allow exemptions later. I was also told by somebody that after they had banned the building of the dam, that some scientists worked on it and they figured out a way of transferring those snail darters to some other place. So they didn't think they could do that, but they figured out how to do it. And then they could go ahead with the dam. But you know, what Rehnquist is saying, well, apparently Congress didn't, when it passed this act, didn't think that we would ever have a case like this where a whole project, a big project like this would be completely stopped. And they probably should have written the act to provide for some sort of exemptions for cases like this, but they didn't do that. They didn't think of that, which is very common to happen in passing legislation. You just can't think of everything. There might be something that you don't. So I can remember my father maybe issuing a decree, we're going to do this and this and this, and then him changing his mind because he didn't think of something. And he would explain to me, well, we're doing it my way. But that was interesting because Rehnquist there, a conservative judge, a judge who, during his placement on the bench, told the Senate he was an originalist, he was for original intent. And he generally is, and he understands the statutes that way, but apparently he also sometimes thinks that you maybe need to not be strictly holding to a law, that there ought to be exceptions to it. There ought to be sometimes exemptions to it, which is very pragmatic of him. Anyway, Torres versus Madrid. Roxanne Torres, a New Mexico woman who was shot twice by state police before driving away from the scene. So they were trying to stop her, weren't they? You know, they approached her car, and she wouldn't obey their orders to get out of the car. She thought they were going to hijack her car. I don't know whether they were plainclothesmen or what. She didn't, you know, she thought these men coming without her gun had some evil intention. So she drove off after they shot her. Now, did you think they thought that she would drive off after they shot her? No. They shot her twice. I guess each of them shot once. And hit their marks, but she still drove off. And Torres filed a civil rights lawsuit against Madrid and Williamson, alleging the shooting was an unreasonable Fourth Amendment seizure. That is, they stopped her. You know, and they didn't really have reason to stop her. There was no reason to suspect her of committing any crime. There was some mischief going on in that parking lot there, but she was not connected with it. They had no reason to think that she was. So why did they shoot her? I mean, you know, they'd probably have been okay if they just had approached her and she drove off. That probably would have been okay. But when they shot her, her argument is, well, that was a seizure. Their argument was that it wasn't a seizure. You know, the word seizure, they said, readily bears the meaning of it laying on of hands or application of physical force to restrain movement. Physical force to restrain movement could include shooting somebody with a bullet. That would certainly restrain a lot of people from moving, depending upon the severity of the shot, obviously so. So why were they shooting her? I think it was to take her into custody. You know, she was driving off, and they thought, well, we can't get her, the only way we can get her is shoot her, so they decided to shoot her. Sometimes I think our police are just not adequately trained. Anyway, physical force, even when it is ultimately unsuccessful. So the word seizure readily bears the meaning of a laying on of hands or application of physical force to restrain movement, even when it is ultimately unsuccessful. Now, the interesting thing about this particular statement is the judge who issued it. This was issued in an earlier case by Judge Scalia. And so, you know, the officers were being represented, the police force was being represented by a lawyer who was arguing for the application of a textual meaning to the thing. So, well, it says it has to be a seizure, and it's not a seizure because, you know, it was unsuccessful, but there's already precedent. And apparently the lawyer didn't know there's already precedent that says that the seizure doesn't have to be successful. In other words, you grab somebody by the shirt or by the body, and he wrestles away and gets loose, and then he runs off. Have you seized him? Yes, Scalia says. You shoot somebody and he drives off. Have you seized him? Yes, says Scalia. You know, and there was actually another case where somebody drove off and shot, and that was also on the books. It was a lower court case. But this Scalia case was a Supreme Court case. A person has been seized within the meaning of the Fourth Amendment only if, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. She, if it appears, was unsuccessfully seized. She was seized, but unsuccessfully. They didn't shoot straight enough. Or she was just too hardy for them. You know, it's just an amazing kind of case. Now, what's interesting about this is it shows you one of the problems with textualism. You can't just say, well, these are the words of the statute, and that's it. Oh, well, we know what it is, you know, and that's it. You've got to understand what those words mean, and the interpretation of words could be different from person to person. So apparently this case has come up before, and so they had to rule on whether or not somebody who was unsuccessfully grabbed or shot, whether or not they were actually seized under the Fourth Amendment, and therefore could apply Fourth Amendment rules to their situation. And obviously, without that, they wouldn't have much of a case against the police, because it provided her with some remedy for the police who had acted illegally in seizing her. Otherwise, they're saying, well, we just wanted to question her, and we shot her, so what? You know, well, she drove off. She wouldn't stay for us. We should, you know, this is what we do. Yeah, it is, and that's what's wrong. Anyway, so Torres versus Madrid, a relatively recent case. So it's been, I think, maybe 2007, 2010, 2012. I'm not quite sure. I did put the date. Anyway, Edwards versus Din, 1976. The defendant went to get gas, filled up his car, asked the attendant to put oil and water in the car, a very reasonable kind of thing to do, while the attendant washed his hands, because, you know, putting the oil and water in the car, he got his hands dirty. While he was washing his hands, the defendant drove off without paying, held his actions did not amount to theft. So they're looking at the statute, the judges are looking at this statute and saying, well, is this a theft according to the statute? And here's what they say. His actions did not amount to theft. In contract, the gas passed as property to the defendant when it was in his gas tank. At that time, at the time of forming the intention not to pay for the gas, it already belonged to him. They're just looking at this one statute, rather than maybe looking at some other statute and saying, yeah, but he owes a debt, and he's trying to get away without paying the debt that he owes. And certainly that's theft. But they don't think about that. They're looking just at the statute. Very dim. And this is an actual case that was decided in 1976 by some judges. It's not the Supreme Court case, but it's by judges. And, you know, they're following a textual rule. So it's sort of like, I think I might have told you when we talked about the Kentucky case, where they were changing the tire, and the guy comes speeding around the corner, and he hits the guy who's helping the lady change the tire, and, you know, his defense is, oh, that guy assumed a risk, and therefore I don't have to pay anything, because the state of Kentucky at that time was still had the rule, the old common law rule, that if you assumed a risk, you got nothing. But they changed that. The judges themselves looked at it and said, we don't think this is a good decision, we're going to change this rule. Common law judges would do that. And so it's the same sort of thing. Another judge, the lower court judge, being a peckerhead, decided that it was okay to let Speedy go on that. You know, yeah, he came running around the corner, endangering everybody on the highway, and hit this poor guy who was doing a good deed. And it's okay if that guy doesn't get any compensation from Speedy. And Speedy's just maybe a little young and foolish. Okay, and whatever. But he's you know, he's following the literal words of the of the common law. Actually, I think there wasn't, I don't think, a statute in that time in Kentucky. It was in 1970, but I don't think they had a statute. They hadn't replaced the common law, that part of the common law with statutes, I think. But it doesn't matter. He was following literally what the words of the precedent or of the law was. So being very much a textualist, he did something which I think is not justice. He said, no, Speedy doesn't have to pay. The Supreme Court in Kentucky had more sense. Those 9 judges there, they decided he should pay. And I support them in that. I support them in not being textualists. Otherwise I would call them peckerheads too. Anyway, White versus Chappell. Chappell, imitating his dead uncle, went to the polling place and voted in his uncle's name. When prosecuted, he claimed that since the uncle was dead, he wasn't an eligible voter, and therefore applying the textual rule, he was not guilty, because the statute says that it was illegal to go in and vote for ineligible voters. And it was to prevent people from stealing other people's votes, you know. So, you know, but here you say, well, he's not dead, he wasn't an eligible voter. And applying the textual rule, he was not guilty. Is this an interpretation we want to follow? Another case. Again, it's not a Supreme Court case. So they're not bound by that. And I don't think they should think they're bound by some sort of textual rule anyway. Because to me it seems like it's just stupid. I mean, obviously, I think you would obviously, to determine what to do, you would first look at the words of the statute, and if they make sense, you'd probably apply them. But in some cases, they may not make sense because the times have changed, or the legislatures didn't think of something, or the legislatures simply were not very good draftsmen. You know? And so, cannot the judges then correct it for the obvious and clear mistake? That's what the mischief rule was about. And intent, a traditional rule. Suppose the judge feels compelled to believe that following the textual rule isn't the will of the people. He decides to look at either what legislators said to the people, looking into speeches in congressional record or televised speeches through which they communicated their intentions in voting for the act. Thus, he says, this method is more in the spirit of a democracy. That is, he's doing the will of the people. Okay, and I think that's true. You know, whereas a textualist simply applies the words as the draftsman wrote them, he's saying, let's look at what they intended to. You don't do that under textualism. You don't. You just look at the words. And what's the ordinary meaning of the words? Like I said, according to Scalia, you would take the ordinary meanings of the words when it was written. So if that was 200 years ago and the meanings of these words changed, well, then, you know, you can't change the interpretation of the statute under the old rule. So that's my problem with the textual rule and textualism. I'm for a living Constitution. I'm for adapting the Constitution to modern times and not to being peckerheads. Anyway, literal rule is an absurdity. The golden rule of statutory interpretation may be applied where an application of the literal meaning of the literal rule, this is one of the rules, right? Literal rule, would lead to an absurdity. The courts may then apply a secondary meaning. You know, so this is a sort of a subdivision. Under textualism, you can actually look at it and say, well, we're going to apply the golden rule. And, you know, we're not going to worry about what the legislators maybe intended, maybe. We're not looking at whether or not they, what do we think they should have been intending. And we're going to, if the words can be construed differently under a secondary meaning, we're not going to take the first meaning that comes to mind. And, you know, you've seen that in statutes where there's more than one meaning, sometimes very similar, very close, but not exactly the same. And we're going to do justice by applying whichever meaning seems to be the just and right one. So it's basically trusting the judges to do their job of being judges and being familiar with the law and being familiar with people. They apply the law like that. Some of the best judges I've seen when I practiced law were judges who had experience outside of being judges. They didn't come from academia. They were, in one case, he was a long-time state police officer and then became a judge. He got a law degree and he became a judge. He was a very good judge, though. He had a lot of common sense to his rulings, and he did things in a very pragmatic, practical way. I think that's the kind of judge I want. I think that's the kind of judge American people want. I think that's the will of the American people, is to have pragmatism in our law and not ideology. N. Ray Sigsworth. Sigsworth in 1935 was a son murdered his mother. She had not made a will. Okay. Under the intestacy statute. So if you don't make a will, your possessions will pass according to intestacy. Intestacy basically will generally follow what most people's will are very much like. Your estate will go, what's left after you die, what can be inherited will go to your children first, will go to your parents if you don't have any children, will go to your brothers and sisters if there are brothers and sisters and they're alive, and maybe we'll go to your grandchildren, and in final analysis, if there's nobody within a certain line of a relation with you, you can go to even cousins. It'll sheet to the state, but there's a long list of people you go through, including cousins. I think it ends at second cousins, though. You know, but after that, it sheets to the state. Here, though, this is under intestacy. He's going to inherit, although there's no will. He was her sole heir and stood to inherit her entire estate. And there was a statute, and the English court, this is an English decision, there was a statute that said that, you know, if a person was inheriting through will something, and he killed the person who wrote the will, he cannot inherit through their will. So this was an English court in 1935. So they're following this textualism, and you know, they were being peckerheads. Holding applicable the literal rule would lead to a repugnant result. He was thus entitled to nothing. So they were actually using the golden rule, which is allowing for a different interpretation of the words than that which first comes to mind. They're not looking at maybe what did the legislatures actually intend. And then the legislatures never thought of this situation again. It's the problem. So there was more than one way around the situation. You don't have to get all the way to the purposes rule or mischief rule to reach the result that you want. The golden rule. Let's say the judge, now a prosecutor, finds himself confronted with a case which he thinks is so ridiculous it could not be the will of the people. But he has not got any legislator on file to verify it. The case involves a man, Mr. Sidgwick, who inherits through intestacy from his father, whom he killed. The statute states he cannot inherit anything through will from a person whom he killed, but he can through a textual interpretation. Okay, and so he's going to apply maybe the golden rule without having to go and find what the intention of the legislator was. Did the legislature really intend that this man could get it? My doubts are, and if he did intend, I doubt if he was really representing the people of England. R versus Allen, 1872. Defendant was charged with bigamy. The statute states whosoever being married shall marry any other person during the lifetime of the former husband or wife is guilty of an offense. Under a literal interpretation of this offense, a textual interpretation of this offense, under a literal interpretation of this offense would be possible to commit, since civil law will not recognize a second marriage. Any attempt to marry would not be a valid marriage. So basically they're saying if the statute said that whosoever being married shall marry any other person, he cannot, he's guilty of the offense of bigamy. You can't deny it, right? I think that's what most of the people would have thought. But what did the legislators think at the time? Regardless of what they thought at the time, I don't think it's really the will of the people, and therefore the use of the golden rule allowing a different understanding of the text was used. So they're not literally taking it, okay? And so the golden rule held the word marry should be interpreted as to go through a marriage ceremony. So it's not actually that you got married, but you went through a ceremony which looked to everybody that you were marrying, and maybe your spouse thought you were marrying, but it's not really a marriage. But the statute should be read as to interpret the word marry as to go through a ceremony of marriage. The draftsman didn't write that, though. He wrote marry. And what's the ordinary meaning of that word? That means to marry. Okay. And anyhow, Adler versus George, 1964. Problem with the golden rule. Judges can add or change the meaning of statutes and thereby become lawmakers, infringing the separation of powers. So this is the common complaint about anything that's not a textual interpretation of a statute. That you basically, the judges are not acting as judges, they're acting as legislators. I don't think that's true. It's not like they're making a new rule. This is a rule that was on the book, but was perhaps not understood by the people who drafted the rule. They wanted to outlaw bigamy. They wanted to hold a person responsible for theft when he was driving off from the gas station with gasoline in his tank. I don't think they're making a new law. They're simply interpreting the law that's there in a way that makes sense, that's practical and pragmatic, and is contextual. So what we who hold that we want a living constitution, we say we want contextualism to be there. We want you to look. All these examples I've given you, they're maybe not looking at the general scheme of the legislation on crimes and bigamy. So they're just looking at this one statute and saying, oh well, this isn't bigamy because he married. Well, no, he went to a marriage ceremony. It doesn't say that in the statute, though. So does that mean the judge is becoming a legislator? I don't think so. But I think you need to read these things in context. People understand things in context, and I don't care what the person drafting the statute thought. I don't care if you took a poll of everybody and they thought something that Mary meant Mary, if you just asked them that question like that and didn't put it in a context. And people might say, yeah, if you're married, you can't, and we'd understand it that way. But I think to then take those words too literally, as textualists tend to do, I think it's wrong. But I'm saying that, actually I don't think the textualists actually do that. Not totally. But there are cases where they do it where it's wrong, because they're not looking at the context in a much greater way. And sometimes you need to look at it in a much greater way. Okay, now I'm going to talk about the mischief rule, which was the old rule which operated in this country right on up until judges began to think they were textualists. The case, it originally arose in a case called Hayden's case, okay? And it's an English case because it was in 1535, but we adopted the English common law. And one of the things that courts applied in this country was the mischief rule in cases where it didn't seem that looking just at the words of the statute fit the intention of the people who drafted it, or the intention of the people who, how people understood it. So there's two ways of doing original intent. Either way, you can run into problems with it not being really quite what you think it should be. And so the mischief rule basically was adopted for all these years and ran and did a good job, and was one of the reasons I think that common law had such a good reputation and was so loved by judges, because it did give them an opportunity to do what they knew was justice. And you might say, well, they shouldn't be doing what they think is justice because they're not legislators. But I'm saying they're not legislating. They're simply looking at the law and trying to figure out what people want the law to be. They want to do justice. Justice is what people want. And and so they're trying to do that. Now they can be overruled by another set of judges, okay? And have been nowadays. Usually textualists will overrule them, whereas in the past they would overrule textualists and literalists sometimes, who were not maybe thinking about how the law is ridiculous when looked at literally or even textually. So anyway, the rule arose in Hayden's case. Like I say, it involves freeholds. It was not a freehold estate though, and so it goes back into very ancient law on owning property, and it talks about things that we no longer talk about. We no longer have these kinds of holds that it talked about, so they decided to apply a rule which would be more appealing to modern people in the 16th century, right? 1535, that'd be 15. It was actually pursuing a statute that was drafted and implemented by Henry VIII, who wanted to use it to take the money out of the religious monasteries, and that's what he did. He passed a law and allowed them to take their money, but we're not going to get into that. Anyway, first, what was the law before the act? So the rule is that in looking at a case and applying an interpretation to a statute, you look at what the law was, what was the law before the making of the act. First you say, well, what was the law before it? Then you say, what was the mischief and defect for which, back then it would have been the common law, but nowadays, of course, it would be the statute, did not provide. So you look to, you know, what mischief the law that originally we had was, and then the third thing you do is what remedy the Parliament, or Congress, we would say now, have resolved and appointed to cure the disease of the Commonwealth. So you look at their words and you say, okay, this is what they said. And then, but you don't stop there. You don't say, well, this is what they said, and I'm going to do literally what they said. I can think of times if I did literally what my father said, I'd been in trouble. But since I knew what he wanted me to do, I did what he wanted me to do. And he wasn't going to tolerate me getting too darn smart. Okay? The true reason of the remedy, he didn't see me as being too darn smart if I did the right thing. But he would if I literally sometimes took him for his word. The true reason of the remedy, and then the office of all the judges, is always to make such construction as shall suppress the mischief and advance the remedy. So you know what the Parliament was trying to do. Okay, so you want to advance the remedy and you want to suppress the thing. Can you do that by following the words of the statute? And if you can't, then maybe you need to do something else. Maybe you need a different interpretation. And to suppress the subtle inventions and evasions for continuances of the mischief. So you pass a law to prevent people from stealing money from people, from, you know, maybe, let's say, rich investment companies. They're using the law perhaps to actually steal. And they're looking at the words of the statute and say, well, we're not stealing this money because this is what the law says. Are you going to do what the law says literally, or are you going to do justice for the people who had their money stolen from them? So basically that's what they're saying here. And to suppress the subtle inventions and evasions for which the continues. So, you know, you pass the law, you think you're getting rid of corruption, and then people get smart and try to figure out a way around it. Are you going to handicap the judges and prevent them from doing justice by holding them to some sort of silly standard and making them read statutes in ways that are ridiculous and absurd? Or are you going to give them a free hand to apply the golden rule and the mischief rule? Or even maybe better, the purposes rule, which actually goes a little further than the mischief rule. What remedy Parliament hath resolved and adopted. Okay, so that's that. And for a personal good, and to add force and life to the cure and remedy. So that's what they're supposed to be doing, right? That would be justice. According to the true intent of the makers of the act for the public good. So this is where that ideal that it should be, that the judges should follow the intent of the people who made the act. This was presuming that the people who were making the act were acting for the will of the people. Do they always act that way nowadays? Or are they sometimes corrupted by who contributed a lot of money to their campaign? It wasn't the people, maybe. Who got these people into office that enacted some of these horrific laws that we have had that have caused all kinds of mischief? You know, and interpretations which were not really what it was meant to be. Okay, so here we go. Mischief rule. Rule is more flexible than the golden or literal rule. Certainly, the golden rule is more flexible than the literal rule, and the mischief rule is more flexible than the golden rule, in that the mischief rule requires judges to look over four tasks. So, you notice that it doesn't say anything about them looking to see how this particular statute fits in with the other statutes, maybe involving bigamy, maybe involving theft. It doesn't say you should look at these other things. but it's somewhat implied that they're maybe going to do that because they need to do justice, right? Okay, prevented the common law rules from becoming ossified. So to some extent, this would allow judges to maybe very creatively interpret the statute in a way that did justice according to the current times. That is, they looked at things. So it allowed for a living interpretation of rules. And this is not just simply constitutional rules, but it's also statutory rules. So this all this interpretation applies both to the Constitution and the statute. We're talking about in terms of statutes, but it obviously has an application there. Do we want a rule that was passed by a legislature 40 years ago to be applied in a way that doesn't look to me like the judge intended it, doesn't look like it's going to do the kind of thing that they wanted to do? That's what the mischief rule was about. Let's correct the mischief that's there, and let's support the good parts of the intention of the drafters. You throw that out with textualism and literalism sometimes. Well, literalism almost always. Well, no. Sometimes, I mean, sometimes a statute hasn't become ossified. Maybe its wording are still applicable today, but sometimes not. Okay. Smith versus Hughes, 1960. The Street Offense Act of 1959 made solicitation of public places illegal. The girls were actually selling themselves by parading themselves on the balconies and flirting with the men below, and actually soliciting them, going so far as to say, "Come on up. Do you have any money? Come on up, and we can fix you up," or whatever. But the mischief to be remedied here was public disturbance caused by the girls. The public doesn't want people to be soliciting people. So the statute said that it was illegal to solicit for purposes of prostitution in a public place. They weren't in a public place. They were in a private house owned by them or somebody they knew, and they were soliciting people from that private house, but they weren't in the public place. They were in the private house, on maybe the balcony. Okay. Now the judges, I suppose, might have been able to claim that, well, that balcony was actually still a public place because it can be seen from the public. That might have been one way they could have interpreted it, but they decided to interpret it this way. The gap in the law was that the solicitations were seen in the public despite the girls not being in public. The remedy was to make such displays illegal. Were they then actually passing a new law? If they said, well, it's illegal for you to display yourself because the statute meant to include that in there, was meant to include in there, are they actually then doing it? So this case comes closer to being the judge actually acting as a legislator. But I don't think so. I still don't think he is, because I don't think the people who drafted the statute thought about girls doing this from windows and balconies and motioning to men, going, "It's money, right? It's money. Come here." Yeah, and I don't think that the legislators were necessarily thinking that when they did the thing. And so why can't the judge just fix the statute a little bit and interpret it in a way that allows justice to be done and allows the will of the people to actually be done? I'm sure they would not have enforced the law if they thought that people didn't want it enforced. And that's why I think the police were the police did arrest these girls. Okay, they arrested them, and then the girls' defense is, "Oh, well, the statute says we have to be in a public place. We weren't in a public place. We were in a private house." Well, that's true in some sense, but you're still violating the statute because you're violating the intent of the statute, aren't you? Anyway, the intent of the legislatures. Ask any democratically elected congressman what he intended to enact when he voted for a law. For example, he voted to make it illegal for anyone impersonating an eligible voter to vote for that other person. He probably would say he voted for the wording as representative of the will of his constituents, but should the judge then hold those words to be sacred, holy, and not, say, well, I'm going to interpret those words in a way where it makes sense, that I think really aligns with what the will of these people probably is, and what the legislators should have known the will of these people would be. I think it's obvious to me, it's absurd to say that those girls, were not violating the intention and spirit of the law. I think a very wise person said, it's not the literal meaning of the law, it's the spirit of the law that counts. And I don't have that quotation, but I remember that it's a quotation. When I went through law school, we weren't into textualism too much at that point. That was 1981. I graduated in 1981. At that time, the Federalist Party was formed, led by Scalia, and they were pushing textualism. I went to the first meeting they had in Cincinnati, could have joined up, and I was told by my buddy that in the future, judges of the Supreme Court will be drawn from these people who are in this society. I said, but I don't believe what they're pushing. I don't think they've got the Constitution. I don't think they got the law right. I think what they're doing is not right according to the law. I thought that then. I think it now. I understand what they're doing, but it's not right. So, and I don't care how much you tell me that Scalia was a genius. I don't think he was. I think he was a very Catholic man, and he was very much, and I was brought up Catholic, and he's a very good man, but I don't want him doing his partisanship in the Supreme Court, because he knows the Republican Party basically supports the principles that are supported by the Pope, and the census with abortion and other kinds of things. Anyway, and I think that's a fair statement to say that's what's happening. So, am I being political? I guess, candidly speaking, I am. But I think people would be much better off if we were all more candid and not pussyfooting around and saying, "Oh, I'm just teaching you the thoughts, or I'm just teaching you how to think, or I'm teaching you how different thinking." I've showed you two kinds of things. Yes, I showed you what textualism is. A person who believes in it might have presented it in a little different light, but I presented it in the light that I understand it to operate. Anyway, purposive rule goes beyond the mischief rule, looking for intent not only in the legislative history but also in the statute's inner coherence with other statutes. Necessary to prevent ossification of our laws, still will be constrained by words and intentions of the legislators of the statute, but as they are maybe now understood, and not as they might have been understood in times past. Complexity of language. Words are more often than not convey different meanings under different circumstances and can completely change meanings over time and in other places. Whole cultures change a word and may become unacceptable, carrying an entirely different meaning than it had in the past. Shakespearean scholars know that actually, if some of the words in Shakespeare are actually were probably intended to him to have the opposite meaning of the way they're interpreted today, because the meaning of that word changed over time, so going 180 degrees. And you can think of maybe some words like that. Flammable and inflammable. Okay, we got 3 minutes, and we just have this last one. So I'm going to give you a last kind of case, and this is and the question here is, the issue is a baby carriage a vehicle? Okay, so the statute says operating or driving a vehicle while intoxicated is a misdemeanor. Tom, while drunk, was pushing a baby carriage through the park. Is he guilty? Should it depend upon whether there was an infant in the carriage? Should it depend upon whether there was an infant? For some of us, the answer would clearly be yes. If the purpose of the statute was for safety of the occupant, then yes. If you said yes to that last question, then you were thinking purposively. You're thinking of the context in which the people who passed that law were probably thinking. They were probably thinking we need to protect people who might be injured, and who could be injured if a baby carriage is driven badly. The occupant probably, although he could run the wheelchair, the carriage into somebody else. That would be another thing. But I think we can say that probably if he's only if he hasn't hit anybody, and I used to have a friend, my father had a friend, Jack Ryan, and he used to be drinking 8 bottles of beer. He'd come visit my dad. He'd been drinking before that. I knew he had hired me and I worked for him. I knew he drank all day. And he would drive. He never had an accident. He never got a ticket. He did drive very slowly, so if you were behind him, you would be very maybe upset with him. But he didn't weave when he drove. And he never got a ticket. Nowadays, of course, the police in Indiana will maybe stop you if you drive too slowly. And they'll check you to see if you're drunk and give you a ticket. I'm saying, well, look, if Jack Ryan can drive safely while drunk, then why should we tell him we're going to stop him if he drives slowly? Because that's maybe going to force him to drive fast, and then he might not be able to drive correctly. Well, that's it for today. Thank you very much. I hope you enjoyed it as much as I did.